The designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum podcast, the podcast local governments need to do business. In the chair, it's me, Tyler Smith. On the agenda today, we have new laws heading your way. With the 2025 spring session of the Illinois General Assembly having adjourned, the Quorum Forum podcast is here to give you an update on all the newest laws affecting Illinois municipalities and units of local government. But first, let's take the roll. We have an attorney at Ansel Glink. He advises municipalities, local governments on corporate, labor, employment, land use and economic development matters, and is one of the premier FOIA experts in the state of Illinois. It's officially summer, which means that NFL training camp and fantasy football draft prep is just around the corner, and we're going to ask him about his secrets to draft success. Eugene Bolotnikov is here.
Present.
Eugene, with Saquon Barkley having an outstanding season last year, are we seeing a resurgence of the bell cow running back for fantasy football? And would you suggest our listeners draft a first-round running back to lead their teams to eternal glory in the coming season?
Tyler, that's an excellent question, and one that merits perhaps an hour or longer of separate discussion. Historically, I've always favored drafting the bell cow running back. We know in the early 2000s, people like Larry Johnson, Priest Holmes, Adrian Peterson, Steven Jackson enabled many people to ride their teams to glory. Saquon is one of those people contemporaneously. Whether to take RB in the first round will depend on many things, including league format, PPR, non-PPR, half PPR. Our league here at Ansel Glink is adopting Superflex, which allows starting two quarterbacks, which will ensure some variation in draft strategy, which I think will be beneficial. But I will absolutely endorse taking a running back in the first round and even the second round.
Always interesting draft prep with you, Eugene. And as well, the Eagles' offensive line is one of the best in the league, which contributes to running back success. So hopefully we'll be able to provide our listeners with a full draft podcast in the coming future. But also, and behind the glass for our protection, Engineer Rick is here. We have a quorum. Dear listener, the Illinois General Assembly's spring session recently concluded, sending many bills affecting local governments to the governor's desk. Eugene, what's the first bill our listeners need to know more about?
The first interesting bill that I think our listeners should know about is Senate Bill 1519, which was passed by the General Assembly with important implications for school districts and municipal police departments. The bill, which passed both houses on May 28, 2025, amends the school code to prohibit schools and law enforcement from issuing monetary fines, fees, tickets, or citations to students for municipal code violations occurring while on school grounds, during school hours, or while taking school transportation. Also, beginning with the 2027-28 school year, schools must report to the State Board of Education, or ISB, the number of students who were referred to a law enforcement agency or official, and the number of instances of referrals to law enforcement that K through 12 students received. This data must also be segregated by race, ethnicity, sex, grade level, and note whether a student is an English learner or has a disability. Additionally, beginning on July 1st, 2026, it will be a requirement for any school district utilizing school resource officers, or SROs, to have a memorandum of understanding with municipal police departments addressing, at minimum, some of the following things: defining the role, duties, and responsibilities of SROs, specifying procedures to ensure that SROs have been trained and received specific training on working with disabled students to ensure that those students have appropriate and effective interactions that support the educational and behavioral needs of the students, or that they have received a training waiver under the Illinois Police Training Act. Another requirement is specifying that an SRO is prohibited from issuing tickets or municipal code citations on school property. Another requirement is outlining processes for data collection and reporting for disciplinary reports to be submitted to ISB. And the last requirement is providing for the regular review and evaluation of the SRO program, including opportunities for community and stakeholder input. While many school districts already have MOUs in place with local police departments, regarding SROs and SRO programs. These MOUs should be reviewed to ensure they comply with the new requirements of Senate Bill 1519. As additional context for our listeners, the legislation was passed in response to a ProPublica and Chicago Tribune investigation, which found that despite existing bans on schools fining students directly, some school districts often referred violations of local ordinances to municipal police departments who could thereafter impose fines on students. Many of these referrals included minor infractions such as littering, making loud noises, or swearing.
That's definitely an interesting bill. As a traffic prosecutor for some local governments in Illinois, it's something I've seen fairly recently is some students being referred to traffic court or Cook County Circuit Court for vaping tickets on school property. So that coming into effect, interesting how school districts handle some of these student discipline issues they seem to be facing. Thank you, Eugene.
Yep.
And then the next bill that for our listeners to know more about is House Bill 2022, which was passed by the General Assembly on June 10th, and it addresses impact fees that municipalities use to finance development projects. House Bill 22 amends the municipal code to allow developer donations and impact fees to now include funds that can be used to pay for the cost of constructing a new school building if the necessity of the new school building is specifically and uniquely attributed to the development or subdivision and the school district certifies the necessity and costs. If signed by the governor, this bill will allow municipalities to require new developers for residential developments to pay impact fees to finance new school buildings, which will be required to support any new residential developments.
That's an interesting bill. Another one that I would like to discuss is Senate Bill 1953, which was passed by the General Assembly on May 15th, 2025, and seeks to promote more thorough and transparent hiring practices by law enforcement agencies. The bill amends the Illinois Police Training Act and requires local law enforcement agencies to execute a signed release with any applicant directing any law enforcement agency which previously employed an applicant to produce all prior employment records before hiring the applicant. These employment records include background investigation materials, duty-related physical and psychological fitness for duty examinations, work performance records, criminal, civil, or administrative investigations of conduct, arrests, convictions, findings of guilt, and pleas of guilty or nolo contendere. Say that again. The bill also sets forth provisions concerning procedures for requesting employment records, deadlines for providing the records, penalties for failing to produce records, and an example of an acceptable release form.
That certainly is an interesting bill to keep an eye on, as it is expected to greatly impact the hiring practices of police departments and local law enforcement agencies in Illinois. Now, the next bill for our listeners we'd like to discuss is House Bill 2336, which was passed by the General Assembly on May 21st and allows municipalities and fire protection districts to collect reasonable fees from assisted living facilities and nursing homes to cover lift assistance services provided to the residents of these facilities. Specifically, this bill amends the Fire Protection District Act and the Municipal Code to allow municipalities and fire protection districts to fix, charge, and collect reasonable fees from nursing homes and assisted living facilities to pay for providing non-emergency lift assistance services. These fees can be imposed for every lift assist service provided to a nursing home or assisted living facility after the sixth lift assistance service provided to that specific facility within 1 year. Now, lift assist services is the ones that are provided to a nursing home or assisted living facility by first responders in order to lift a patient from their current position to a desired sitting or standing position. While these lifts do not occur in response to an emergency request or for an ambulance ride to a hospital or emergency room, they can still tax limited resources of municipalities and fire protection districts. This legislation now allows these governmental units to, as we mentioned, fix, collect, and charge reasonable fees to recover some of these costs and hopefully alleviate some strains on their limited financial resources.
Yeah, Tyler, this is a good bill. Any cost-saving measures for units of local government are certainly welcome to our listeners' ears, and I imagine many clients may have questions about that. Another bill I'd like to talk about is House Bill 1842, which was passed by the Illinois General Assembly on May 22nd, 2025. This bill expands the powers of hearing officers overseeing municipal administrative adjudication hearings. Specifically, the bill amends the Administrative Adjudications Division of the Illinois Municipal Code by allowing administrative hearing officers presiding over adjudicatory hearings to enter orders prohibiting further code violations or compelling the remediation of existing code violations. The hearing officers may also authorize the municipality to take all necessary steps to remediate code violations.
That is another great bill for communities and home rule communities throughout the state of Illinois. Specifically, the fact that they can now hopefully be able to more efficiently and cost effectively enforce ordinance and zoning code violations without needing to have to go to circuit court to get an order prohibiting future violations, which is great for our communities and clients. And then the next bill that we'll discuss today is House Bill 1082, which was passed by the General Assembly on May 29th and provides great news to communities and municipalities with populations of less than 1,000 individuals. This legislation amends the municipal code to provide that beginning in fiscal year 2027, which will be July 1st, 2027, any municipality with a population of less than 1,000 residents that does not own or operate public utilities and that has no bonded debt is only required to file annual financial reports with the Illinois Comptroller and will only be required to file an audit report every 4 years. Beginning in FY 2027, the annual audit report requirements for qualifying municipalities will be greatly reduced. And this legislation will hopefully help alleviate some of the financial burden that smaller municipalities face from conducting audits and reporting requirements, which used to, before this legislation, would have been required every year.
Yeah, that's another interesting bill. Another one that I'd like to discuss is House Bill 2458. Which has not been passed by the General Assembly. It is an important bill for municipalities to be aware of moving forward. This bill was introduced in response to the Illinois Supreme Court's decision in 2024 called Camacho versus City of Joliet. For our listeners who may not be aware of this case, the Camacho case allowed Illinois home rule municipalities to assess fines in cases involving the movement of motor vehicles or reportable offenses under the Illinois Vehicle Code. Historically, such cases could only be handled by the Illinois Circuit Courts and not through a municipality's administrative adjudication system. House Bill 2458, if passed, would have prevented any home rule county or municipality from using their administrative adjudication system to adjudicate an offense under the Illinois Vehicle Code that is a traffic regulation governing the movement of vehicles, or an offense that is reportable to the Illinois Secretary of State under the Illinois Vehicle Code. The bill was passed by the House of Representatives in April 2024, but to date was never passed by the Illinois Senate. But nevertheless, this bill is certainly one for home rule communities to be aware of moving forward insofar as it can circumscribe some of the things that can be done pursuant to administrative adjudications.
That is a fascinating bill and one that I'll certainly be keeping my eye on. I know some communities have greatly appreciated being able to adjudicate some moving violations through their administrative hearing systems and just the ease I'm sure that police officers have being able to attend those hearings versus going to circuit court for some of those is something that's probably greatly helped to reduce enforcement costs. So that's something Absolutely. We'll certainly be keeping an eye on. Now, the next bill that we'll talk about today is Senate Bill 39, which was passed by the General Assembly on May 31st and exempts qualifying newly constructed residents for veterans from requirements of the Electric Vehicle Charging Act. Now, under this bill, any tiny home, which is defined as an individual detached residence of no more than 800 square feet, constructed for veterans who are either homeless or at a risk of experiencing homelessness, will be exempt from the Electric Vehicle Charging Act's requirement that any newly constructed residences in Illinois must have at least one EV-capable parking space. To qualify for this exemption, the tiny home must be built by a nonprofit organization that exclusively funds and administers projects and services for veterans. Additionally, and to note, manufactured homes will not qualify as a tiny home under this bill and are not eligible for the exemption from the Electric Vehicle Charging Act's parking requirements. Now, municipalities play an important part in the implementation of this exception. Every county and municipality that has the power to issue building permits must require by ordinance that an applicant seeking a building permit to construct tiny homes for at-risk veterans must include in the permit application a signed affidavit stating that all buildings constructed under the permit are designed for the exclusive use of qualifying veterans. Further, this bill also now prohibits counties and municipalities from adopting building codes or ordinances that require EV-capable parking spaces for the qualifying affordable tiny homes built for at-risk veterans.
Wow, a bill about tiny homes, but one with a large impact on some of our communities. It's hard to follow that, but I will try. I also want to discuss Senate Bill 1550, which was passed by the General Assembly on May 21st, 2025, and provides new grant opportunities for libraries in Illinois. The bill amends the Illinois Library System Act to include planning construction grants to library systems and public libraries that are members of a library system, as well as grants to improve or enhance security in libraries. There have been several threats of violence against libraries in recent years, which has prompted this new legislation intended to aid libraries in obtaining enhanced security measures to better protect library staff and patrons.
As someone who has fond memories of going to my local library growing up, that is a very interesting and important bill, and hopefully will help allow future generations in Illinois to continue enjoying these very valuable public resources. And speaking of libraries, the next bill we'll talk about, House Bill 1910, also has a huge implications for libraries throughout Illinois. House Bill 1910 was passed on May 21st and amends the Illinois Local Library Act to require public libraries to maintain a supply of opioid antagonists, commonly known as Narcan or Narcolone, in an accessible location. This act, as amended by House Bill 1910, provides that authorized personnel may administer the medication to anyone they believe in good faith to be experiencing an opioid overdose on library grounds in the immediate vicinity of a library or a library-sponsored event. Libraries must also ensure that during operating hours, at least one employee or staff member is present who has received training in how to recognize and respond to an opioid overdose and how to administer this medication. Health departments in any county where a library is located may provide a supply of opioid antagonists to the library. A library and its authorized personnel, additionally, are immune from liability for the administration of these medications under the bill, except in cases of willful or wanton misconduct, which is an important and high threshold in civil litigation cases. So that does help provide some important protections to library staff who will be hopefully will not have to undertake life-saving efforts, but if they do have some degree of comfort and protection. Additionally, there are two further items of interest we want to bring attention to for our listeners on this important bill. First, this bill only amends the Local Library Act, and there appears to be no corresponding legislation passed in this session to amend the Public Library District Act. While the bill states that these new requirements apply to all libraries open to the general public in Illinois, the Local Library Act, the specific statute which amended by House Bill 1910, only covers public libraries established under the Local Library Act and not library districts. This raises an important question as to the scope of House Bill 1910's application, given the inconsistency of the language used in the bill, i.e., applies to all public libraries, and the only statute the bill proposes to amend, i.e., the Local Library Act. Second, this bill provides that libraries may obtain an approved opioid antagonist from any lawful source, but does not reference funding to cover the cost of acquiring these medications or training for library personnel. Absent further legislation, grants, or opportunities for funding, libraries may need to be prepared to cover the costs associated with compliance for this bill on their own. This bill has been sent to Governor Pritzker for consideration, and if signed into law, Illinois libraries, or at the very least, those libraries established under the Local Library Act, will be required to stock a supply of opioid antagonists, work with staff to complete the required trainings, and otherwise ensure compliance with the requirements of this new law. And then the next bill that we'll also be talking about today is a very, very important piece of legislation, which is House Bill 2755, and it is the state of Illinois' budget for fiscal year 2026. House Bill 2755 was passed by the General Assembly and signed into law by Governor Pritzker on June 16th as Public Act 104-006. Now, this is a very important, any budget is always important for the state of Illinois, but this fiscal year 2026 budget is especially important to municipalities as it amended several revenue provisions of the municipal code relied on by communities throughout Illinois. This 2026 budget legislation amended the Tobacco Products Tax Act under the municipal code by raising the tax rate for tobacco products. Effective July 1st of 2026, the tax rate for tobacco products will be raised to 45%, and the definition of tobacco products under the Tobacco Products Tax Act is broadened to include products such as nicotine pouches, gums, and vaping products. Additionally, this 2026 budget amends the Hotel Operators Occupation Tax Act to now subject short-term rental properties to the Hotel Operators Occupation Tax. Effective July 1st, rental platforms will now be required to collect this tax on short-term rentals and render tax payments to the Illinois Department of Revenue. Lastly, the 2026 budget bill delayed the 2023 annual tax sale, which the Cook County Treasurer's Office anticipates will be delayed until March of 2026.
That's another really useful bill for our clients and listeners to know about. Another one that I'd like to discuss today is Senate Bill 2264, which was not passed by General Assembly during the spring 2025 legislative session, but it is an important bill to keep an eye on for future legislative sessions. The bill seeks to limit the circumstances under which a tenant could be evicted under a local crime-free housing ordinance and would bar a municipality or county from enforcing or applying a nuisance or crime-free housing ordinance against tenants who contacted emergency services, are victims of crimes or domestic violence incidences, or have an arrest record. However, the bill would not prevent enforcement of these types of ordinances against a tenant who perpetrates crimes, for example, domestic violence, dating violence, sexual assault, stalking, or other criminal activity. Any municipality or county with a nuisance or crime-free housing ordinance would need to hire a crime-free housing coordinator who would handle cases where law enforcement informs a landlord that a tenant should be evicted. The coordinator would then review the cases and decide whether the tenant's actions warrant eviction. Tenants would then be permitted to challenge an eviction in circuit court and file a lawsuit against the municipality seeking injunctive and monetary relief, including attorney's fees and costs. It's also important to note for our listeners that this bill contained an express preemption provision that would have prevented a home rule municipality or a home rule county from regulating tenants in a manner inconsistent with the bill. While this bill was not passed in 2025, it may be reintroduced in future sessions, so certainly a bill to keep an eye on.
That certainly will be a very important bill to keep an eye on. Any housing bill, it's been especially a housing bill addressing crime-free housing ordinances, is sure to spark intense and spirited debate among the legislature. The next bill we're going to talk about is Senate Bill 1563, which was passed by the General Assembly on May 21st and seeks to create anti-squatter protections for property owners and homeowners. This bill increases protections for property owners by amending the Illinois Code of Civil Procedure to provide that nothing in the eviction article may be construed to, 1, prohibit law enforcement officials from enforcing criminal trespass laws or any other violation of the Illinois Criminal Code, or 2, to interfere with a law enforcement officer's authority to remove people or property from a premises where a criminal trespass has occurred. Now, this bill received near unanimous support in the state legislature, with only one vote being cast against its passage when it was considered in the state Senate. Without this amendment to Illinois laws, it can take over a full year for a property owner to regain possession of a property after a squatter has entered and criminally trespassed on the premises, which can incur significant emotional and financial costs to the property owner who is pursuing an eviction process. If the governor signs this bill into law, homeowners and property owners will have stronger legal protections against criminal trespassers, and squatters moving forward. And moving forward, as this is a regular meeting of the Ansel Glink Quorum Form podcast, we will now open the floor for public comment. A municipal FOIA officer writes, I recently received a Freedom of Information Act request seeking the video recording from an incident where a police officer responded to a public disturbance instance involving a municipal employee. This employee was internally disciplined, and the incident video was used as evidence in the employee's disciplinary hearing. Are we required to produce a copy of the video, or can we deny this FOIA request?
So that's a really interesting question, and usually interesting questions don't correspond with appropriate opinions or cases on point. In this case, we have one. The Illinois Attorney General's Public Access Counselor recently issued guidance on this specific issue. Generally, while FOIA provides that the public may have access to inspect and copy public records in the possession or custody of public bodies, there are certain records that could be redacted or withheld from a response to a FOIA request if one or more applicable exemptions apply. In this case, FOIA Section 71N exempts records related to a public body's adjudication of employee grievances or disciplinary cases. In the case of a recent PAC opinion 25004, the PAC determined that exemption 71N only applies to records which are related to an adjudication of an employee's disciplinary case if the record is created in the process of conducting the adjudication itself. In this PAC opinion 25004, the PAC determined that a municipal police department committed a FOIA violation by withholding a video recording of a former police chief's DUI arrest. At the time that the municipality received the FOIA request, they argued that the video recording was exempt in its entirety pursuant to 71N because the recording was allegedly used in the adjudicatory process where the former police chief was disciplined. However, in this case, because the video was created on the date of the DUI arrest and not in the process of the former police chief's actual adjudicatory hearing, the PAC determined that Section 71N did not apply because the recording should be produced in response to the FOIA request because the creation of the video recording preceded the initiation of any relevant adjudicatory proceeding regarding the former chief. In our listener's case, I apologize. In our listener's case, 71N would not apply to withhold the recording.
That is unfortunate news for our listener, but a treat for the rest of our listeners getting to hear one of the premier experts in the state talk about the Freedom of Information Act. And then the next item on our agenda today brings us to the Department of Public Works. Eugene, are there any relevant publications or upcoming conferences or presentations that our listeners should be aware of and check out?
I'm glad you asked, Tyler. There certainly are. Ansel Glink recently published an article in the APA Illinois June newsletter discussing how municipal planners can seek to address the toward immunity implications of growing e-scooter and e-bike use in their communities, as well as some publication about for newly elected municipal officials. Ansel Glink has published a 2025 guide for newly elected officials, which is available on our firm's website. Also, Ansel Glink attorneys will be presenting on several topics at the upcoming 2025 APA Illinois State Conference, which will be held in Chicago in October 2025, and we hope to see our listeners there.
That 2025 guide for newly elected officials is a great resource with many communities experiencing and having new officers sworn in after the 2025 consolidated elections, hopefully bringing in some new energy and ideas to help make their communities better. Thank you, Eugene. You have any final thoughts or fun summer plans you'd like to share before we adjourn today?
Circling back to the beginning of the podcast, Tyler, it's fantasy football season, so my draft prep is ramping up. I've created my spreadsheets, which will be revised many times hereafter. Perhaps even an opportunity for us and others to collaborate on a fantasy football episode of the Quorum Forum podcast. Other than that, no other plans.
Very exciting. Any insights that you would care to share on who you expect to be the highest scoring wide receiver this year for fantasy football?
Oh, that is regrettably confidential. That's within my notes.
Make the people subscribe and pay for any draft insights. Always a good business model.
Yeah.
Now, before we go, we would like to remind everyone to subscribe and leave us a review wherever podcasts are heard. As always, we prefer good reviews. You can send us any questions and or show ideas at our email at podcast@anselglink.com. Or you can leave us a voicemail for a future public comment in an upcoming episode at 312-604-9178. And please visit us online at quorumforum.anselglink.com. Do we have a motion to adjourn?
So moved.
Do we have a second?
Second.
Wow. All in favor?
Aye.
The ayes have it. See you next time on Ansel Glink's Quorum Forum podcast.